Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Well, hello there, and welcome once again. Ask a Lawyer here on CP24. Good to have you along for the ride this evening. Next 30 minutes, you're going to learn a lot. That much we can guarantee as we shadow the myths and misconceptions about employment law. My name, John Scholes, co-hosting this week with me, John Pincus. It's the John Show on Ask a Lawyer. Want to reach out right away. I always give you the information off the top to reach out to John on your own time. He's got a great team with him. Phone call first, 1-855-821-5900, ask@employmentlawyer.ca. There's some more contact information we'll give you throughout the show. We'll get some phone calls from one of our long-running radio shows over the course of the next half hour. And we always have a main topic, don't we? This time is termination of employment, setting the record straight. You need to know this information. Now, if you've watched the show in the past, you might have heard some of this already. You've been well-educated and well-steeped in employment law knowledge. But if this is your first time, this is a great half hour for you, especially if you have a job in Ontario, in Canada. You'll need to know this stuff. So that's all coming up shortly, our phone calls, et cetera, and some emails. But John, we always start off with the week that was, pal. Case of the day, what's cooking in your world?
Well, yeah, there's lots going on, and very important that people watch this show, and we'll always do it as long as people will tell us that, I didn't know that my rights were what they were until I saw the show, and I didn't realize that my severance rights were so straightforward to enforce. And here's a good situation, a good example of that with this situation. Someone come to me and said, I just lost my client of 25 years. Am I entitled to severance? So I'm putting client in quotation marks because although they were formerly a client, this is someone who worked exclusively, one company, 25 years, worked for them on a full-time basis, had a boss there, had a shared office space, had participation in company meetings, company email. And so for all intents and purposes, it really was not much different from being a commission salesperson from another company. They didn't negotiate their own prices. They exclusively sold the company's products, and they were pretty integrated into the company. But on paper, they were a contractor.
Right.
And when they got terminated, when they lost their contract, when they lost their client, the contract said, we have to pay you 30 days. That's all we're going to pay you. That's all we owe you. And she said, after 25 years, that seems a little light. So sure enough, I went through these details with her. And although it looked like on paper she was a contractor, in reality, and as far as the law was concerned, she was an employee, which means that she was entitled to all the same entitlements as any other employee, including, very importantly, severance. And in this case, this was someone who was owed as much as 2 years' pay. So this was the difference of over $100,000 for this person, right? And we're going to be negotiating this for this salesperson, and it's going to be fairly straightforward to do. So there are important lessons here for employees and employers, right? For employees, the lesson to be drawn is just because your employer says something, just because a contract says something, does not make it so. And employers should draw the same lesson. When someone comes to me and says, I want an independent contractor, the first question I ask them is this person really operating at an arm's length? Because what the law cares about is the situation on the ground. And if the situation on the ground does not match the reality of the situation, if this person really is in business for you and not in business for themselves, then no matter how good your contract is, it's not going to be worth the paper that it's written on.
It's kind of that in-between thing where you could be a dependent contractor where the vast majority of your income comes from one client, as you say, but you could still be owed severance. That's kind of what this case looks like, right?
Right. Well, this was a little bit different because it was beyond just dependence. There really was that employment relationship. There really was that control that is characteristic of an employment relationship. A dependent contractor, if she had been a dependent contractor, she actually would have been out of luck because the dependent contractor, if you have a contractual provision that says this is all you get, then that may be all you get as a dependent contractor. Right. If you're a dependent contractor without a written contract, then you have entitlement to severance.
As I mentioned off the top, guys, phone calls from a radio show. You want to join in, just go to EmploymentLawyer.ca to find a radio station in your hood. Locally here in the GTA, News Talk 1010, Sundays at 1 p.m. Would love to get you to join the show sometime. It's a complete hour on Sunday afternoon. Maybe your phone call will appear on this show, and we'll talk about it. Phone call number 1 from the radio shows is coming up right now. Have a listen.
I've been temporarily laid off, and if my employer does not end up calling me back because the situation doesn't improve, let's say, at what point am I entitled to severance at that point or holiday pay?
How long have you worked there for?
5.5 years.
And what kind of a job, and how old are you?
I am almost 60, and it's an administrative position, I guess.
What do you think, Johnny?
Well, the first thing that this person should know is when you are laid off, if you have not agreed to it in a contract, so you haven't signed off on your consent, I agree to layoffs, or you haven't expressly told your employer, okay, I'm okay with this layoff, then by default, you don't have to agree to a layoff, right? If you haven't agreed to it and agreed to it in a very express way, then you can treat that as a termination, which means that you do not have to wait until the end of the layoff. You can say, I'm not agreeing with this. Even if a few months have gone by and you haven't said anything, it's not too late. You can say, I'm treating this as a termination with the help of a lawyer, and you have the same severance entitlements as everyone else. Or conversely, if you want to give your employer a chance to call you back, maybe you really want to hang on to the employment relationship, maybe it's part of a family business and you want to give them a chance to call you back, times are tough, great, all the more power to you. Wait until that period is over, and if they don't call you back at the end of the statutory period, which may be either 13 weeks or 35 weeks, depending on whether you have continued benefits, then you're also going to have the same severance entitlements as everyone else. So let's take a look at the Pocket Employment Lawyer and see what this particular person is entitled to, right? So 60 years old, an administrative role up for 5 years. This person's going to be entitled to about 6 months of their pay, so that's about $27,000, right? So a significant amount of money, and they may not want to wait to find out if the employer calls them back, right? That's an important choice. It's a personal choice, but you have to know that it is a choice that you have unless you've given them permission to do that.
We will take a short break. By the way, you have access to that severance calculator as well, PocketEmploymentLawyer.ca. But termination of employment, we are setting the record straight on the other side of the break as we continue. Lots more Ask a Lawyer here on CP24. Stick around.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer. This is CP24. John Scholes here. John Pincus joining me this week. EmploymentLawyer.ca to reach out, and by phone. That is always available to you. That number, 1-855-821-5900, or email ask@employmentlawyer.ca and scan that little QR code in the top right anytime you would like as well. Okay, main topic every week, and this week, no different. We have one, termination of employment, setting the record straight. Let's get into these talking points. John, first one is this: your employer can let you go even without a good reason. Break that down quickly.
Right. This is a common misconception, often because people conflate U.S. law with Canadian law, which treats wrongful dismissals very differently. They mean very different things. But in Ontario and in Canada, if an employer lets you go, that's not a wrongful dismissal just because they didn't have a good reason, right? So a question that's often asked, can they let me go because I'm a top performer? Yes, they can. Can they let me go because I looked at them the wrong way? Yes, they can do that. Why? When are situations where they cannot let you go? Well, they can't let you go if you have asked for accommodation and that is the reason they're letting you go. If you've taken a leave of absence, if you have tried to exercise some right under employment standards, like try to enforce your overtime or your vacation pay, and they terminate your employment in response to that, that's called a reprisal. Can't do that. Also can't reprise against an employee because they have refused to do unsafe work or they've made a workplace safety complaint. There are severe repercussions for that. But outside of those situations, which are relatively rare, an employer can let you go for almost any reason they want. And in that case, they have to pay you the proper severance. Mm-hmm. The only way that they wouldn't have to pay you the proper severance is if they have just cause for dismissal, which is very, very rare. But we're concerned when we're talking about a termination, not with so much do they have the right to let you go, because chances are they do, but have they paid you the proper severance, taking into account your age, your position, your length of service?
Number 2 is this, John. It's difficult to fire an employee for cause. Break that down.
It's not just difficult, it's very difficult. It's not impossible, okay? There are situations where you can terminate an employee for cause if they've committed theft, serious dishonesty, intentional fraud, things like that, those really egregious things where it's just impossible for the employer to continue employing you, then it's just cause. But we call it the capital punishment of the employment law relationship. This is something that was actually cooked by a judge and is commonly referred to because it really puts it into perspective. And you just got to think, how often is capital punishment really the proper response to misconduct in the workplace? And that's why 90% of the time someone comes to me with a for-cause termination, it's an illegal termination.
We're talking termination of employment. We're setting the record straight. Number 3, this one is huge as well. If you take away one point of the show, this is it. Severance is not solely based on what the Ministry of Labor tells you should get or what the employer wants to pay you, right?
Right, especially what the employer wants to pay you. I mean, if people thought that, then people would be taking a lot of crummy severance packages. The Ministry of Labor, very important point as well. The Ministry of Labor is good for certain things. They're good for vacation pay. They're good for overtime pay, statutory holiday pay while you are employed. Once you lose your employment, the Ministry of Labor is typically not the place you want to go. If you actually want to get your full severance entitlement, the Ministry of Labor cannot help you with that. You have to go and pursue your full common law entitlement, and typically you're going to want a lawyer to help you navigate that. And it's a very important choice because if you go to the Ministry of Labor and you go through that process and then at the end of it you realize, oh, you know what, I should have gone through a lawyer, it's too late. It may be too late and you may not be able to withdraw that application and then you're stuck.
One more point on termination of employment, John, is this: you do not have to sign that termination severance pay letter right there on the spot. In fact, don't, right? Right.
I mean, it would be very ill-advised to sign something where you're giving something away without understanding what you're giving away, without understanding what you're signing. And that deadline is only meaningful if you're going to accept that offer. And in many cases, in fact, in most cases, you probably should not be. And I can tell you as someone who writes termination letters for employers, I have never written a termination letter that did not include a deadline because employers like you want this thing to be done. They want closure. When an employer is putting on a deadline, it's not necessarily because they're trying to trick you. It's because, just like you, they want the thing resolved. But if you go to an employment lawyer and you decide, you know what, actually, this is not a severance package I'm willing to accept because I'm entitled to a lot more, at that point, the moment you decide to negotiate, it's meaningless. Doesn't matter at all.
All right, good stuff. We got lots more to go here. In fact, we're going to get to our second phone call of the show right now. Again, reminder, here locally in the GTA, News Talk 1010, Sundays, 1 p.m. Join us and call in and take part of that show as well. John, here's your second phone call for the show. Listen up.
I worked for about 2 years. When I began work, I asked for accommodation and was immediately put on short-term disability. I was denied long-term, but then given a position which I was subsequently unable to do because of my disability and need for accommodation. I was put on short-term disability again and have just been denied long-term disability for the second time. Wondering if there's anything I can do.
Good call. What do you think?
Right. Well, the first thing that you want to do is you want to go to a disability lawyer, right? Because long-term disability benefits are very important. They often eclipse the entitlement to severance pay, and you want to make sure that you handle that. But you also want to coordinate it with an employment lawyer, because if you're getting problems from your employer saying, well, you know, your disability provider says that you're not sick, so you're ready to go back to work, and if you don't go back to work, we're going to treat it as abandonment, that's a problem that you have to deal with those things together, right? So you want a law firm that can deal with those things together, and you want that to be coordinated. But if you have a doctor's note that says this person is unable to work at the moment because of some kind of medical condition, whether it's psychological or physiological or what have you, then that has two very important implications. Number one, chances are you're going to be entitled to long-term disability insurance. Very, very important. And just because the insurer says something does not make it so. And number two, you're going to be entitled to accommodation from your employer. And your employer also cannot rely on what the insurer says as gospel, because it's not. That's not the law.
And the saving grace is John and his colleagues at the firm, the other half of the hallway covers disability law as well, so you can reach out to the same number, which I'll give you on the other side. Lots more to go. And phone call number 3 from the radio show is coming right up as we continue Ask a Lawyer here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back. Ask a Lawyer, CP24. John Scholes along with John Pincus from EmploymentLawyer.ca. Reach out to John anytime you want to have a conversation on your own. If there's matters you need to discuss, first the phone number, always 1-855-821-5900. Email ask@employmentlawyer.ca and scan that QR code as well. Did mention the phone calls. We try to get 3 in every show from one of our radio shows. We're pretty much across the country, but we focus heavily here in the GTA. News Talk 1010, our sister station, Sundays 1 p.m. is where we get these phone calls from. John, here's your third phone call. Let's have a listen and discuss.
On Monday, the foreman actually told me that we have to reduce hours to Monday, Wednesday, and Fridays. And I just wanted to know if there's any way I can make them give me regular hours. I just can't afford to live off 3 days a week.
How long have you worked there?
9.5 years.
And how old are you?
54.
Know the answer to this one. Yep.
Right. Well, the first thing that we have to look at actually in these situations is what was the deal, right? As this person signed onto a contract that says, you can put me part-time, full-time, this hour, that hour, variable. And if that contract says that your hours are going to be variable and they can change without notice, then you're kind of stuck, right? Which is why it's so important to be mindful when you're signing these contracts. Let's assume this person doesn't have a contract. Hours of work are considered a fundamental, essential term of employment. And if an employer wants to change that, they can't do that without either giving you sufficient notice or giving you sufficient severance, right? And if they do that without giving you notice or severance, that's going to be a wrongful dismissal, which means that you're going to have the same entitlement as if they simply told you your employment's terminated without cause, right? So let's pull up the Pocket Employment Lawyer and see what this person is entitled to in these circumstances, right? 9.5 years working there as a laborer or a labor category in any event, earning about $63,000 a year. 10 months pay, right? Very significant amount of money because that person, let's assume, didn't agree to this in advance. So it underscores, first of all, that you should speak to an employment lawyer when these changes are happening, because if you wait and you allow these hours to just become kind of the modus operandi, right? Business as usual, then you may not be able to do something about it. And the other thing is that you need to be careful when you're signing on to these employment agreements that you're not giving the employer the right to do this, because you may not care. You may be focused on, oh, here's my salary. Okay, here's my start date. All sounds good. But sometimes the devil's in the details. And I have seen clauses that allow employers to do this.
Let's grab a quick email, John, before we take one more break. It goes like this. I understand that employees in a federally regulated workplace don't have the same right to severance pay as a provincially regulated workers. Is that true?
Well, the answer here is yes and no, right? It depends if we're talking about minimum entitlements or full entitlements. Right. But for all intents and purposes, for what we care about on this show and what for most people listening to this and watching this are going to care about, the answer is no, the entitlements are the same. The entitlements are different because if you are working in a federally regulated industry, such as a bank, such as telecommunications, or certain transportation companies that cross national or provincial boundaries, then you're going to have different entitlements by statute, right? You're going to have different minimum entitlements. If you're in certain positions, you may actually have the right to seek reinstatement. So there are certain things that you get as a federal employee that you don't get as a provincial employee and vice versa. But when we're talking about your full severance entitlements, your entitlement upon termination to be paid termination pay, we're looking at your age, your position, your length of service, and the entitlements are the same. Doesn't matter.
Great email. Thank you so much for that. We'll take one more short break and get to another question on the other side for sure. Ask a Lawyer continues here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back. Ask a Lawyer, CP24. In addition to lawyering, John Pincus, our lawyer today, also does a lot of radio shows, TV shows, and he does live streaming as well. He's a busy guy. You want to join in anytime. Facebook, YouTube, LinkedIn, at stlawyers.ca is how you go about doing that. From one of your live streams, John, here's a question. I just found out I'm pregnant. I'm afraid to tell my boss because she has a history of finding ways to get rid of pregnant staff to avoid mat leave disruptions at work. What should I do?
You know, I get this question so often, and I'll start with the harsh reality, right? The harsh reality of these situations is that no matter what the law says, you can't really force your employer to do anything, right? There are certain situations where you can seek reinstatement, certainly a situation like this, where if the employer misbehaves, you could seek compensation, but you typically can't force your employer to do anything. So I can't come in and say, you cannot fire this person and actually physically stop them from doing that. That being said, you have a right under multiple statutes. You have a right under the Employment Standards Act. You have a right under the Human Rights Code to protection against discrimination on the basis of pregnancy, right? And that's a specific right, specifically outlined for that. And the law punishes employers who don't abide by that severely. So the idea here is under the law, you should not be anxious about having to disclose this to your employer because the law recognizes that you have a right to take a pregnancy leave and to not experience not only termination, but any kind of reprisal for being pregnant. And if you do, there are severe consequences to the employer. There can be human rights damages, and if they terminate your employment at a time when you are pregnant, you're also going to have an elongated and elevated severance entitlement. So the best thing I can say is that the law is here to protect you. It can't stop your employer from firing you, but you are entitled to protection by way of compensation.
I know we have to break here in a minute or go in a minute, but I know the employer still has a business to run while you're off. Do they have the right to hire somebody, but you have to get your job back, the exact job when you come back from your mat leave, yeah?
Well, of course, it's acknowledged that the employer has to run their business, right, and they'll have to hire someone when you are away. And if that position truly doesn't exist for reasons that have nothing to do with your pregnancy, then it is possible for the employer to eliminate the position. But generally speaking, when you come back, they have to hold your job or put you in a comparable job.
Covered a lot of ground on the show tonight. Thank you so much for tuning in and contributing. By the way, you can reach out anytime to John and his team. Now that we are done, phone call always 1-855-821-5900. Ask at EmploymentLawyer.ca. That website, PocketEmploymentLawyer.ca, has that severance calculator rolled into it. And any other information can be found cp24.com/askalawyer. And we'll catch you next week right here. Another edition of Ask a Lawyer. Coming right back then.